So that is important. So family trust. So a family trust, which is what you hear people talk about every now and then, is the kind of trust that family members create for the benefit of other members of the family. It could be that the breadwinner of the family has assets and has plans for the minor children and for disabled members of the family, or even for his or her partner who he or she believes will benefit from the trust. The owner or the head of the family or the family breadwinner may then say, okay, I am going to move these assets into a trust. And this trustee will take care of these assets, and the benefits arising from these assets will be enjoyed by this person in this way. So you can create that in a will. You can also create it as a living trust. So a family trust may be a testamentary trust, and it may also be a living trust. It doesn't matter. The only thing that makes it a family trust is that it is usually created to take care of the family needs and circumstances. So the question is usually asked, should I create a family trust? Why should I do it, and when? The simple answer to this is that it depends on your needs and objectives. If you don't need a family trust, you don't have to worry about it. If you think you don't need it. If you think you do need it, you can think about whether or not you want to create a living trust, or whether or not you want to create a testamentary trust. Most times, most families actually need the testamentary trust, not the living trust. Because when I say most families, I mean that if you do not have lots of assets, if the value of your estate is not so big, you really don't need to get into the complicated aspect of creating a trust and a living trust and incurring costs for an estate that is not big. You can make a will and create a trust within your will. And that is as good as any kind of trust. The only thing is it speaks after you're gone. That's probably what you need. And then some people create trusts, some families that are well-to-do, that have lots of assets, create trusts so that they can protect certain assets from claims from creditors. And like I said, you may create a trust when you are not sure whether or not minor or disabled children may be able to manage assets properly. And you may also create trust to be sure that the assets are intact for your own benefit or for the benefit of loved ones in the future. And of course, if you have children or minor or even adults that have special needs, which you want to ensure that are being met, you may create a trust to take care of that. So, should I appoint a professional trustee, or who do I appoint as my trustee? So, like I said, if you are talking about a will, the executor is the trustee, usually. And for you to make somebody your executor, you must know the person very well. And you must know that the person is going to be able to carry on the responsibility of an executor. You know your people well. You know people that are close to you. You know people that can do certain things. And you know people that you can trust to do A or B. And people that you can trust not to do A or B. So you have to assess the situation and decide on who you want to appoint. When you have looked at your assets and the obligations that you would like the executor or your trustee to carry out. And after speaking to professionals to get some advice, you might realize that people that you think might be good might not be good for that position. And then the question is, who else do you go to? Then you look at option B and all of that. Then you might settle on somebody, get the person appointed, or approach the person to see if the person can do it, and realize that no, or the person might then realize that no, this is too much of an obligation for me. I might not be able to do it. So all these things, like you not being able to find somebody that's suitable, or the person that you think might be suitable not thinking that they can do it, or not being willing to do it, and you not being sure of whether or not a suitable person might be good for it, or you anticipating that there might be some conflict in the family regarding this, if this person does it or that person does it, you might then think about appointing a professional trustee. So a professional trustee might be a company. There are trust companies that do things like administering trusts. There are individuals that you may appoint, like a lawyer or an accountant, who can help in dealing with your trust. The thing is, when you appoint a professional, be it a trust company or an individual or a lawyer or an accountant, these people do know the system better. They at least understand the fundamentals of trusteeship. They understand the obligations of trusteeship, and they are likely going to be more diligent in administering the estate than a lay individual can. And the beneficiaries are likely going to see them more as impartial people than other people who are not non-professionals, especially if that professional, if the professional in question does not have any kind of personal connection to the person who created the trust. And the professional is likely going to be more knowledgeable and familiar with the steps that are required to administer complex and high conflict estates. But when you appoint a professional, you got to pay for the services rendered, and the payment usually comes out of the estate, the trust, and the fees payable to the professional might become another source of conflict among competing parties. They might even challenge the professional, especially if one of the some of the contestants or beneficiaries believe that the trustee is biased in favor of any of the beneficiaries. So,
Barrister.
yeah.
So I do have a couple of questions. So sometimes when we're creating these policies, trust policies, like an insurance policy, we have clients who say, okay, so-and-so is going to be trustee for my children. And we know that they didn't ask them. So does somebody have to get the permission of a trustee before they name them as a trustee in, say in a document, like let's say life insurance?
Yes, it is important to let the person who you are appointing as a trustee know. Because if a trustee is appointed and the trustee says, no, I'm not going to act, you don't have a trustee there. You cannot compel somebody to act. So in a situation like that, somebody will have to make a court application for a trustee to be appointed, or that particular policy might have to fall back into your estate, which might not be what we had intended to see happen. So it's always a good practice.
And there's another situation where somebody could appoint a trustee who does not live in the same country. So I've had situations where a client says, okay, my family is in Nicaragua. So I'd like my uncle in Nicaragua to be the trustee for my child here in Canada. What do you say to that?
So you have the choice to choose whoever you want as your trustee. However, if you can avoid it, it is not something that you should do if you can avoid it. It is better to look for somebody in Canada, not just in Canada, but somebody in Alberta. The reason being that if the person is out of jurisdiction, financial institutions might be reluctant to deal with the person, and because the person is out of the jurisdiction, and before they can deal with the person, they might request the person to post a bond so that they are sure that whatever that is getting into this person's hands is protected. For example, if somebody is in Nicaragua or somewhere else outside Canada, and that person is supposed to be a trustee of, say, a life policy that's worth 500,000, and they get the 500,000, wire the 500,000 to the person, and the children who are the beneficiaries are in Canada, and the children are not getting this. How can you bring the person to account for the money? But if you have somebody here and the person gets the money, and it's not being used for the children, for the beneficiaries can make an application to say, we need you to account for this money because it is their right, or request that they be provided with information as to what is happening, or ask for a report on what has happened from at this time to that time. So it is fraught with challenges, such type of appointments, getting somebody out of the jurisdiction. It is not something that you should do, except if you have no other choice. But if you live in Alberta, you should have somebody in Alberta. If you don't have somebody, you go for a trust company that's in Alberta. You don't go outside Alberta. Or if you can go outside Alberta, please don't go outside Canada to appoint somebody. Yes.
Got it. And so when you're talking about a trust company versus a lawyer or an accountant, what is the difference between a trust company and a law firm when it comes to that?
A trust company is a financial institution that is licensed under the law in Alberta to administer trusts, administer different properties that are in their hand, that are vested with them as the trustee. So it is their job to administer trusts of different types. They provide reports whenever they need to. They make sure that they comply with the duties of a trustee. And when you have a trust company dealing with it, you're likely going to have a particular officer that you're dealing with. If anything happens and that officer is out, they get it reassigned. And you're protected. Even if that company folds, those assets are protected by the government. So you do not have to worry about it if you're using a trust company. But a lawyer is just a lawyer. You appoint a lawyer to do it, and the lawyer gets paid to do it. And if the lawyer, for any reason, passes on, the trust agreement or the trust deed is likely going to say, in the event of this person not being able to act or this person passing on, that this will happen. So another person will take over. And the same thing will happen to an accountant. It will happen if you have an accountant as a trustee. But having a professional is a good thing. Some lawyers, like a lawyer who has created the trust deed or who has worked with you all through the process in building the trust, setting it up, might not be willing to act as the trustee because it might raise some questions about a conflict. But in reality, there is no conflict in my view if the person just took instructions from you and created it, and you then say, okay, this would be my trustee. But you never know, the beneficiaries might challenge it. And if the beneficiaries challenge it, that same lawyer might end up being required to testify. So that's the potential for a conflict that is there. But it won't be difficult to get an accountant or a different lawyer to act as a trustee, but the trust company is always there if you need them.